Diplomatic immunity is a form of legal immunity that ensures diplomats are given safe passage and are considered not susceptible to lawsuit or prosecution under the host country's laws, although they can still be expelled. Modern diplomatic immunity was codified as international law in the Vienna Convention on Diplomatic Relations, which has been ratified by all but a handful of nations, though the concept and custom of such immunity have a much longer history dating back thousands of years. Many principles of diplomatic immunity are now considered to be customary law. Diplomatic immunity as an institution developed to allow for the maintenance of government relations, including during periods of difficulties and armed conflict. When receiving diplomats, who formally represent the sovereign, the receiving head of state grants certain privileges and immunities to ensure they may effectively carry out their duties, on the understanding that these are provided on a reciprocal basis. Originally, these privileges and immunities were granted on a bilateral, ad hoc basis, which led to misunderstandings and conflict, pressure on weaker states, and an inability for other states to judge which party was at fault. An international agreement known as the Vienna Conventions codified the rules and agreements, providing standards and privileges to all states. It is possible for the official's home country to waive immunity. This tends to happen only when the individual has committed a serious crime, unconnected with the diplomatic role, or has witnessed such a crime. However, many countries refuse to waive immunity as a matter of course. Individuals have no authority to waive their own immunity. Alternatively, the home country may prosecute the individual. If immunity is waived by a government so that a diplomat can be prosecuted, it must be because there is a case to answer and it is in the public interest to prosecute them. For instance, in 2002, a Colombian diplomat in London was prosecuted for manslaughter. Once diplomatic immunity was waived by the Colombian government. History. Ancient times. The concept of diplomatic immunity can be found in ancient Indian epics like Ramayana and Mahabharata, where messengers and diplomats were given immunity from capital punishment. In Ramayana, when the demon king Ravana ordered the killing of Hanuman, Ravana's younger brother Vibhishana pointed out that messengers and diplomats should not be killed or arrested, as per ancient practices. During the evolution of international justice, many wars were considered rebellions or unlawful by one or more combatant sides. In such cases, the servants of the criminal sovereign were often considered accomplices and the persons violated. In other circumstances, harbingers of inconsiderable demands were killed as a declaration of war. Herodotus records that when heralds of the Persian king Xerxes demanded earth and water of Greek cities, the Athenians threw them into a pit and the Spartans threw them down a well for the purpose of suggesting they would find both earth and water at the bottom, these often being mentioned by the messenger as a threat of siege. However, even for Herodotus, this maltreatment of envoys is a crime, and he immediately recounts a story of divine vengeance befalling Sparta for this deed. A Roman envoy was urinated on as he was leaving the city of Tarentum. The oath of the envoy, "This stain will be washed away with blood," was fulfilled during the Second Punic War. The arrest and ill-treatment of the envoy of Raja Chola by the king of Kulasekara dynasty, which is now part of modern India, led to the naval Canilure War in AD 994. Pope Gelasius I was the first pope recorded as enjoying diplomatic immunity, as it is noted in his letter Duo Sun to Emperor Anastasius. As diplomats by by definition enter the country under safe conduct. Violating them is normally viewed as a great breach of honor, although there have been numerous cases in which diplomats have been killed. Genghis Khan and the Mongols were well known for strongly insisting on the rights of diplomats, and they would often take terrifying vengeance against any state that violated these rights. The Mongols would often raze entire cities in retaliation for the execution of their ambassadors, and invaded and destroyed the Khwarezmid Empire after their ambassadors had been mistreated. The beginnings of modern immunity. The British Parliament first guaranteed diplomatic immunity to foreign ambassadors in 1709, after Count Andrei Matveyev, a Russian resident in London, had been subjected to verbal and physical abuse by British bailiffs. Modern diplomatic immunity evolved parallel to the development of modern diplomacy. In the 17th century, European diplomats realized that protection from prosecution was essential to doing their jobs, and a set of rules evolved guaranteeing the rights of diplomats. These were still confined to Western Europe and were closely tied to the prerogatives of nobility. Thus, an emissary to the Ottoman Empire could expect to be arrested and imprisoned upon the outbreak of hostilities between his state and the empire. The French Revolution also disrupted this system, as the revolutionary state and Napoleon imprisoned numerous diplomats who were accused of working against France. More recently, the Iran hostage crisis is universally considered a violation of diplomatic immunity. Although the hostage-takers did not officially represent the state, host countries are obligated to protect diplomatic property and personnel. On the other hand, during World War II, diplomatic immunity was upheld and the embassies of the belligerents evacuated through neutral countries. For the upper class of the 17th, 18th, and 19th centuries, diplomatic immunity was an easy concept to understand. The first embassies were not permanent establishments but actual visits by high-ranking representatives, often close relatives, of the sovereign in person. As permanent representations evolved, usually on a treaty basis between two powers, they were frequently staffed by relatives of the sovereign or high-ranking nobles. Warfare was not between individuals but between the sovereigns, and the officers and officials of European governments and armies often changed employers. Truces and ceasefires were commonplace, along with fraternization between officers of enemy armies during them. When prisoners, the officers usually gave the parole and were only restricted to a city away from the theater of war. Almost always, they were given leave to carry the personal sidearms. Even during French Revolutionary Wars, British scientists visited the French Academy. In such an atmosphere, it was easy to accept that some persons were immune to the laws. After all, they were still bound by strict requirements of honor and customs. In the 19th century, the Congress of Vienna reasserted the rights of diplomats, and they have been largely respected since then, as the European model has spread throughout the world. Currently, diplomatic relations, including diplomatic immunity, are governed internationally by the Vienna Convention on Diplomatic Relations, which has been ratified by almost every country in the world. In modern times, diplomatic immunity continues to provide a means, albeit imperfect, to safeguard diplomatic personnel from any animosity that might arise between nations. As one article put it, so either we agree to a system in which we dependent on a foreign country's whim before we can prosecute a criminal inside our own borders. The practical answer is, because we depend on other countries to honor our own diplomats' immunity just as scrupulously as we honor theirs. In the United States, the Diplomatic Relations Act of 1978 follows the principles introduced by the Vienna Convention Conventions. The United States has had a tendency to be generous when granting diplomatic immunity to visiting diplomats, because a large number of U.S. diplomats work in host countries less protective of individual rights. If the United States were to punish a visiting diplomat without sufficient grounds, U.S. representatives in other countries could receive harsher treatment. If a person with immunity is alleged to have committed a crime or faces a civil lawsuit, the State Department asks the home country to waive immunity of the alleged offender so that the complaint can be moved to the courts. If immunity is not waived, prosecution cannot be undertaken. However, the State Department still has the discretion to ask the diplomat to withdraw from her or his duties. Often, the diplomat's visas are cancelled, and the diplomat and her or his family may be barred from returning to the United States. Crimes committed by members of a diplomat's family can also result in dismissal. Exceptions to the Vienna Convention. Some countries have made reservations to the Vienna Convention on diplomatic relations, but they are minor. A number of countries limit the diplomatic immunity of persons who are citizens of the receiving country. As nations keep faith to the treaties with differing zeal, other rules may also apply, though in most cases this summary is a reasonably accurate approximation. The Convention does not cover the personnel of international organizations, whose privileges are decided upon on a case-by-case basis, usually in the treaties founding such organizations. The United Nations system has a relatively standardized form of limited immunities for staff traveling on UN laissez-passer. Diplomatic immunity is often granted to the highest-ranking officials of these agencies. Consular officials formally have a more limited form of immunity, generally limited to their official duties. Diplomatic, technical and administrative staff also have more limited immunity under the Vienna Convention. For this reason, some countries may accredit technical and administrative staff as attaché. Other categories of government officials that may travel frequently to other countries may not have diplomatic passports or diplomatic immunity, such as members of the military, high-ranking government officials, ministers, and others. Many countries provide non-diplomatic official passports to such personnel, and there may be different classes of such travel documents such as official passports, service passports, and others. De facto recognition of some form of immunity may be conveyed by states accepting officials traveling on such documents, or there may exist bilateral agreements to govern such cases. Formally, diplomatic immunity may be limited to officials accredited to a host country, or traveling to or from the host country. In practice, many countries may effectively recognize diplomatic immunity for those traveling on diplomatic passports, with admittance to the country constituting acceptance of the diplomatic status.